Hi, folks. Very good afternoon to all of you. Today, I'm very happy to be here to be able to present myself in terms of chambers. My name is Thurgood Kanoh. I first had myself registered in 1995, so almost 100 years ago, because I had myself registered in the 20th century. I belong to Anderson Mori, which is one of the four big firms located in Japan. And Anderson Mori was established in 1952, I believe, by several American lawyers who entered Japan after the end of the World War II. And now we have around, I suppose, 600 or more than 600 lawyers throughout Japan. And I have been concentrating on labor and employment matters and antitrust and competition matters for the past 29 years. And today, I'm so happy to be able to discuss some aspect of the Japanese employment law, which is a unilateral termination of employees. First and foremost, shall I say, it would be extremely difficult to unilaterally terminate employees in Japan. This is basically because the law prohibits companies from doing that. The law says companies are prohibited from terminating employees unless there is a persuasive reason. And the interpretation of the persuasive reason, it's very narrow. Judicial judges have interpreted this language as very narrow. The fundamental take on this on the part of judicial judges would be, well, employees could be educated and trained and coached and guided properly by their companies. So judicial judges expect companies to educate, coach, guide, and train employees whose performance is poor so that they will be bettered as good employees. That's the expectation that the judicial judges may have. Because of this, it's quite, I'd say, extremely difficult to satisfy the persuasive reason that I referred to. Basically, several factors that we'd have to substantiate. The first one is, with respect to the annual performance appraisal, SABCD, you've got to score employees as D instead of B. However, in many situations that I have encountered for the past 29 years, companies score B or even A under SABCD. But we'd have to substantiate poor performance. And A or B does not mean the performance is poor. B means the performance is mediocre, and A means the performance is rather good. So if the performance appraisal indicates A or B, it's very difficult to substantiate a poor performance of the subject employee. And secondly, what kind of statement or what kind of actions or even inactions would constitute the appraisal of D. What kind of well, she or he is expected to do this, or she or he is expected to say this, but she or he has failed to do so. Specifically, what happened? This is the second point, and it would be very difficult to substantiate this point also because usually their subordinates or their colleagues or their supervisors would have to make a statement specifically what has happened. But they are very worried about potential retaliation. Employees whose performance is poor may try to retaliate their colleagues if their colleagues say something bad toward them. So there is a possibility that colleagues, supervisors, or subordinates may be very frightened if they were requested by their companies to state what actually happened. So this is the second factor. The third factor is in some situations, well, yes, the performance of the subject employee may be poor, but it may not be attributable to her or him. It may be attributable to some other factors that is uncontrollable. Say, well, a good example is the COVID-19 period, during which time employees, the performance of some employees must have been quite poor. But this is inevitable. This was inevitable because some uncontrollable factor made that situation. So can we prove that the fact of her or his performance is attributable to her or him? This is the third point, and it's also difficult to substantiate because employees whose performance is poor tend to argue that, oh, look, there is a possibility that my performance may be poor, but it's not attributable to me. It's attributable to my supervisor. It's attributable to my client, or it's attributable to the government, or it's attributable to society. Anything they could refer to. So can we rebut these potential arguments? This is the third. The fourth point is, has the company given some good period of time during which time employees are allowed to improve and better their performance? Say, not 3 months or so, but to say at least 6 months or 1 year, some good period of time has been given. That's the fourth point. The final point is employees have the employees being subject to a PIP, or have the employees being transferred from the current position, from their current position to another position. This is the fifth point, because poor performance exhibited at one position does not mean that she or he may exhibit the poor performance at another position or after she or he experiences PIP. So judicial judges expect companies to do something so that their performance will be better. For example, by a PIP or a transfer, internal transfer to another position. So this is the fifth important factor. Basically, judicial judges consider that companies have the authority to internally transfer employees from their current position to a different position. That's what companies are allowed to do in Japan. So instead of unilaterally terminating employees, judicial judges consider that it would be wiser for companies to transfer employees from their current position to a different position, so that they will continue to be utilized by their company, and there is a possibility that their performance may be bettered. So that's the basic mentality of judicial judges in Japan. And as you have already understood, these factors are quite hard to satisfy. All of these factors shall be satisfied for the purpose of unilateral termination of employees. And it would be very difficult to satisfy all of them. And if your company terminates employees without satisfying any or all of these 5 factors, then employees might file a lawsuit. Employees might resort to the employment tribunal. The employment tribunal, by the way, is a simplified type of lawsuit, which would be finalized within a basically 4-month period. And thoroughly, employees might join a labor union, which is outside your company. There are many labor unions that employees are always allowed to join. And if an employee joins one of these outside labor unions, then this labor union is allowed by the Constitution of Japan to request your company to hold an opportunity to discuss anything about this employee, which is called collective bargaining. So this labor union, outside labor union, even if it is outside labor union, still it's considered to be a labor union. And this labor union can request your company to hold collective bargaining. And the important point is this labor union does not have to have the majority of employees of your company. If one employee joins a labor union, then the labor union is guaranteed by the Constitution of Japan to request your company to discuss everything related to this employee. So this is very different from the US system, I suppose. And still, in many situations, employees join outside labor unions. And these an official lawsuit, the employment tribunal, and joining an outside labor union, these 3 are frequently seen. And it would be wiser for your company to try to avoid all of these potential ramifications. And for that purpose, if your company should avoid a unilateral termination, then probably the method should be trying to request an employee whose performance is poor to consider her or his peaceful resignation. And a peaceful resignation is different from a unilateral termination. If she or he is okay with her or his resignation, it's a resignation, as opposed to a unilateral termination where employees do not want to get separated, but they are forced to get separated. That's a unilateral termination. So we should aim at trying to achieve the goal of peaceful resignation, if possible. And for that purpose, obviously, what is important is money, unfortunately, and how much your company would to be able to come up with. That's practically important. The law does not mention anything. Judicial judges may not mention anything. There is no standard, but well, everything depends, and it depends. Say, in some situations, 1 year of service corresponds to 1 month's remuneration. So if the employee has been with your company for 6 years, then 6 months remuneration. That's one type of calculation. But if an attorney has started to represent the subject employee, or a labor union has started to represent the subject employee, the amount of the money, which may be able to be described as a type of sweetener, so to speak, the amount will become larger, such as a 1 year remuneration or 2 year remuneration. It's up to negotiations between the two parties. So if both parties reach an amicable settlement by your companies coming up with a good amount of money, which the subject employee could accept, then the case will be over, which is a happy ending. However, if employees try to stick with some unreasonable amount, such as 5 years remuneration, and your company can only make a payment of, say, a 1 year remuneration, in those situations, negotiations will fall apart and reach an impasse. In which situation, what your company can do is either to transfer that employee from her or his current position to a different position. By the way, in that situation, with the same amount of remuneration as opposed to a reduced amount, unless she or he is okay with the reduction, or continue to use her or him at her or his current position, or running a risk and unilaterally terminating the subject employee and fighting at the Tokyo District Court or other district courts and trying to reach an amicable settlement at the Tokyo District Court or other district courts. So choices may be very limited. But usually being involved in a lawsuit would be far from productive, and continuous collective bargaining sessions with an outside labor union. They're also time-consuming and far from productive. So usually, it would be wiser for your company to try to come up with some good amount whereby to try to persuade the subject employee. And if both parties reach an amicable settlement, both parties are allowed to enter into a resignation agreement, which would have some provisions in order to protect the interest and benefit of your company, such as confidentiality and no defamation, and no credit or debt between the two parties, and no lawsuit in the future. So in exchange for receipt of some sweetener, employees will promise to do this, promise not to do this. So these points can be referred to within the potential resignation agreement. So that's also important. And by way of coming up with a good amount of money, and by way of entering into an amicable settlement agreement or resignation agreement, there is a strong probability that she or he will be gone peacefully, and the case will be over. Usually, I'd recommend this approach compared with unilateral termination of the subject employee, because being involved in a lawsuit or the employment tribunal or collective bargaining with outside labor unions, any of them is quite time consuming and onerous and maybe costly. Especially regarding a lawsuit, it could take, I'd say, at least 2 years at the district court level. And if a judgment is rendered, then the losing party will appeal the case from the Tokyo District Court to the High Court, in which situation more time will have to be consumed. And none of them is productive to the interest of your company. So I'll try to recommend that your company should try to come up with some sweetener and enter into a resignation agreement. Thank you very much. My name is Thurgood Kanoh. Thank you for watching.